Well, I had a moment. Thank you for supporting me. Like, I've been thinking about blocking that person for a couple of weeks now, and that was just the last straw. Like, I just couldn't take it anymore. By the way, that's what I look like when I'm on the side of an issue. If I believe strongly about something, that's how I behave. So, anywho, feels good to have gotten that out. Also, they reported me for community guidelines violation, so I blocked them. We'll see if they try to come back. This will be fun. Okay, so I haven't really looked at much today because I've been stuck on a mediation all day, but I've sort of picked out some FAQs, some things that have been asked over and over again about the dismissal, so I thought I would do a quick video to try to answer those. Can evidence that was obtained in discovery for claims that are no longer alive be used in the other case with Blake Lively? Yes. You can use any evidence for any case you want to. So as long as it's relevant to the case you're trying to use it in, and as long as it's admissible in court in the trial that you're trying to use it in, you can use evidence even if the claims are gone. So the answer to that is yes. Friedman put out a statement. For what it's worth, I didn't really care for either party's lawyer's statements. I didn't like Gottlieb's and I didn't like his. But he's put out a statement saying we have 4 claims to replead, whereas it looks from the dismissal order like it's 2. And the reason is the judge's fault, because he called claims something in the order that's not the title of the actual claims in the amended complaint. So in the amended complaint, there's a breach of her employment contract, breach of the implied covenant of good faith and fair dealing in that contract. And he said breach of implied contract. He meant that one. So that's definitely one. And then the complaint also has 3 other claims that all relate to WME. Intentional interference with contractual relations, intentional interference with prospective business advantage, and negligent interference with prospective business advantage. But the judge, when citing in the order, said tortious interference with contract. And so it's hard to tell whether he meant one of those, 2 of the 3, or all 3. And Friedman is reading it, of course, that he gets to try with all 3 plus the other one. But frankly, it's hard to tell. The judge will have to tell us whether that's true or not. But nobody's saying things out there that aren't true or whatever. It's just not clear from the judge's order because the judge didn't use the names of the claims as they appear in the actual complaint. So you can't match them up. If Baldoni were to win the case against Blake Lively, successfully defend himself, can he then go back and sue her for defamation? Probably not. And the reason for that, there's 2 reasons for that. One is just because you prevail in a civil case, you get the preponderance of the evidence, 50.1%, does not mean that what the other person said was a lie. It's not even close. The other reason is because of the statute of limitations. The statute of limitations for defamation in California is only a year. Now, so, by the time we got to the end of a trial, he'd be well past the statute of limitations. Now, the fact that he filed this complaint, even though it's now been dismissed, would it relate back? I don't know, maybe. But I think you should assume that that's not going to happen. I just don't see legally how that occurs. And I don't think he would have the evidence to meet that standard. Can Lively use the claims that got dismissed in her case about retaliation? No. Because Baldoni's complaint gets the litigation privilege, just like the CRD complaint of Lively's got the litigation privilege. So you cannot utilize something someone said in litigation in a formal pleading as evidence of their guilt, or this is civil court, as evidence of their liability. Should Wayfairer have filed motions to dismiss now that we know this judge is inclined to grant them? I still think no, because they were not going to get granted on the sexual harassment or the retaliation. I see those claims all the time. I know what the allegations look like to get you past a motion to dismiss, and she had them. So I don't think it would have been helpful for them to file motions to dismiss on all the other ancillary claims that most people don't even know the names of. They could have filed a motion to dismiss on the employment contract, and said she had to attach it or something, but I think they decided it wasn't worth it. So I still think if their goal is to go to trial fast, I don't think that would have helped them, even though I know this judge is inclined to grant stuff like that. I think it probably does have them thinking carefully about motions for summary judgment, which is the motions to throw a case out after all discovery has been done based on the fact that there aren't any issues of fact for a jury to decide. If this judge is not afraid to dismiss a case at the dismissal stage, that also means he's not afraid to grant summary judgment. So that'll be interesting. Did the Lively folks file a new motion for sanctions based on this? No. What they did is they had already filed these motions for sanctions, as you know, based on basically the issues in the complaint. The Baldoni Wayfairer people responded to them. And what they did was they filed a reply to one of them, which I suspect they're going to file replies to all of them. So, you know, it goes motion, response, reply. And in the reply, they say, well, the judge just threw these out. Ergo, they're frivolous under Rule 11 and we should, you know, they should get sanctioned. Who knows right now, but I just don't see that happening. The judge had that in front of him on the primary motion and he didn't grant it. He didn't mention it. I just don't think he's going to do that. It's not like I said in my very first video, saying that there isn't an issue because someone has failed to state facts upon which relief can be granted does not make it frivolous. So it's not a new motion, it's just the motions they have out there and the judge will decide when he's going to rule on those whenever he does. He did enter an order on a bunch of the motions to compel. These are all moot, nobody cares. And that's why we now know that's why he wasn't responding to those, because he knew he was going to throw those claims out anyway. Can Lively just withdraw her claims? This is fascinating. This never would have occurred to me. And people seem very convinced. And I trust people who are looking at this outside of me. So because we have gotten past the answer stage with her case, like you can just pull your complaint and your claims. If somebody hasn't responded to it yet, you can just pull it, right? Because we're past that, either everybody has to agree to it, so Wayfairer would have to agree to it, or if they don't agree to it, they'd have to go in front of the judge. It's very much like the situation that we just had with the intentional infliction, emotional claims, right? Where Lively said, I'll drop them, but I'm going to do it without prejudice. And Wayfairer said, well, we're not going to agree unless you do it with prejudice. And they're like, we have to get the judge to decide this. It would probably look something like that. And it would then be up to the judge to decide what are all the considerations. He's probably going to eventually let her. She doesn't have to prosecute a case she doesn't want to prosecute. But he might say something like, well, you're going to have to pay part of the fees that they've put into this for getting here because, you know, they thought, you know, what's the harm to them in it getting dismissed now? He can consider all of the different equities that are in play there. It seems from Friedman's statement like they are going to replead. You know, I've always thought the WME stuff was really interesting. If it's what Reynolds said in his motion to dismiss, that the WME contract says either one of us can terminate this contract at any time, that's going to be I think that's probably going to dismiss those claims, because you can't destroy someone's future contract when the contract destroys itself. But on the other claim, on the claim of Lively's employment contract, that I want to see, because like all of you, I'm dying to see what that thing says, because as of, what has it been, 6 months now almost, none of us have ever seen it.